Hey everyone! Welcome back to the channel where we make preparing for your UBC real estate exam simple and stress-free. In today's video, we're diving into Chapter 6, Commercial and Residential Tenancies, with 45 practice questions to test your knowledge and boost your confidence. Whether you're tackling commercial leases or navigating residential tenancy rules, these questions will help you solidify key concepts and ace this chapter. Hit that like button and subscribe for more real estate exam prep content. Let's jump in.
Chapter 6, Commercial and Residential Tenancies. Question 1. Which of the following examples would not entitle a landlord to terminate a residential tenancy under the British Columbia Residential Tenancy Act? Correct answer. B. Jean Paul, a landlord, wants to give notice to Velma, a tenant, so that Jean Paul's nephew, who is moving to Vancouver, can live there. Explanation. Under the British Columbia Residential Tenancy Act, a landlord cannot end a tenancy to accommodate a relative unless it is for the landlord themselves, their spouse, or a close family member as specified by the Act, e.g., parent or child. A nephew does not qualify as a close family member for this purpose. Additional notes. A. Late-night disturbances that disrupt other tenants could be grounds for termination based on interference with the peaceful enjoyment of other tenants. C. Consistent late payment of rent can justify termination as it breaches the tenancy agreement. D. Failure to pay a security deposit within the agreed-upon timeframe is a breach of the tenancy agreement and can justify termination. Question 2. Which of the following statements is true with respect to security deposits in a commercial tenancy? Correct answer. The amount of a security deposit may be freely negotiated between the two parties to a commercial lease. Explanation. In commercial tenancies, the terms of a security deposit, including its amount, are not regulated by the same rules as residential tenancies and can be negotiated freely between the landlord and tenant. This flexibility is due to the commercial nature of the agreement, where parties are considered more equal in bargaining power. Additional notes. A. Interest on security deposits is not a mandatory condition in commercial leases unless specified in the lease agreement. C. The Interest Act does not impose restrictions on security deposit interest in commercial leases unless stated in the contract. D. The concept of unconscionability may apply in extreme cases, but there is no legal limit, such as 150%, for security deposits in commercial leases. Question 3. Which of the following is not subject to the provisions of the Residential Tenancy Act? Correct answer. D. A house leased for a 29-year term. Explanation. The Residential Tenancy Act, RTA, does not apply to lease agreements for a term of 20 years or more, including those for a 29-year term. Such leases are considered long-term agreements, often akin to ownership, and fall outside the scope of the RTA. Additional notes. A. Residential condominiums rented by owners are subject to the RTA. B. Apartments rented separately from non-residential spaces, like a warehouse, fall under the RTA. Basement suites rented as residential spaces are subject to the RTA. Question 4. A lease of real property is a contract by which the landlord conveys. Correct answer. B. Exclusive possession to the tenant. Explanation. A lease grants the tenant the right to exclusive possession of the property for a specified period in exchange for rent. This means the tenant has control over the property and can exclude others, including the landlord, subject to certain rights like inspections with proper notice. Why not the others? A. An easement. This is a non-possessory right to use another's land, not a lease. C. A license to occupy. A license allows use of the property but does not grant exclusive possession. A right of survivorship. This pertains to joint ownership arrangements, not leases. Question 5. A lease granted by a tenant for a term that is less than the whole of their remaining interest granted in the original lease is referred to as, correct answer, C. A sublease. Explanation. A sublease occurs when a tenant, the original lessee, leases out the property, or part of it, to another party, the subtenant, for a term that is shorter than the tenant's own remaining lease term. The original tenant retains some interest in the lease and remains responsible to the landlord under the original lease agreement. Why not the others? A. An assignment. In an assignment, the tenant transfers their entire interest and obligations under the lease to another party, leaving no remaining interest. B. A tenancy by sufferance. This arises when a tenant remains in possession of the property without the landlord's consent after the lease has expired. D. A tenancy at will. This is a tenancy that can be terminated at any time by either party, usually informal and without a fixed term. Question 6. Which of the following statements is true with respect to security deposits in a commercial tenancy? Correct answer, C. The amount of a security deposit may be freely negotiated between the two parties to a commercial lease. Explanation. In commercial tenancies, the terms regarding security deposits, including the amount and conditions, are typically a matter of negotiation between the landlord and tenant. These terms are not heavily regulated like in residential tenancies. Why not the others? A. The interest that accrues on a security deposit is always paid to the account of the landlord. This is not universally true, as the handling of interest on a security deposit depends on the specific terms of the lease agreement. B. Someone who purchases the property from the landlord is obligated to repay the security deposit to the tenant. The new property owner is usually obligated to honor the tenant's security deposit if it was part of the terms of the original lease agreement. However, this is not explicitly true for all cases without the agreement being clear. D. All of the above. Since A and B are not universally true, this option is incorrect. Question 7. In which of the following situations may the landlord choose to give the tenant 1 month's notice of the end of the tenancy agreement? Correct answer, D. McGregor's son is moving to Vancouver and wants to live in an apartment that McGregor owns and has rented out to Mrs. Julian for the last 20 years. Explanation. Under the Residential Tenancy Act, RTA, in British Columbia, a landlord can end a tenancy with 1 month's notice if the landlord or a close family member, e.g., son or daughter, requires the rental unit for personal use. However, proper notice must be given, and the landlord may also be required to compensate the tenant in some cases, such as providing 1 month's rent as compensation for ending a tenancy. Why not the others? A. Charles is renting a 1-bedroom apartment and Christine has moved in. The presence of an additional occupant is not sufficient grounds for eviction unless the tenancy agreement explicitly prohibits it, and even then the landlord must follow proper procedures. B. Jordan's house needs renovation. Renovations requiring the tenant to vacate typically require 4 months' notice, not 1 month. Additionally, this applies only if permits for the renovation are in place. Kirsten refuses to pay the security deposit. Failure to pay a security deposit as per the tenancy agreement could result in the landlord ending the tenancy, but the landlord must follow proper procedures and cannot unilaterally issue a 1-month notice in this situation. Question 8. A tenancy that automatically renews itself on the last day of the term for a further term of the same duration until terminated by either party with proper notice is called correct answer, C. Periodic tenancy. Explanation. A periodic tenancy is one that automatically renews for successive periods, e.g., weekly, monthly, or annually, unless either the landlord or tenant provides proper notice to terminate it. This type of tenancy continues indefinitely until terminated by one of the parties. Why not the others? A. Tenancy at will. This is a tenancy without a fixed term, where either party can terminate it at any time without notice, subject to legal exceptions. It does not automatically renew. B. Tenancy at sufferance. This occurs when a tenant remains in possession of the property after the lease has expired without the landlord's consent. It does not involve automatic renewal. D. Term fixed tenancy. A fixed-term tenancy is for a specific duration, e.g. 6 months or 1 year, and ends on the specified date unless renewed or converted to a periodic tenancy. It does not automatically renew. Question 9. Where a commercial tenancy is expressed as lasting for a period of 1 year and terminating on a fixed date, how much notice must be given to terminate the tenancy? Correct answer, A. No notice is required. Explanation. In a commercial tenancy with a fixed term and a clearly defined termination date, no notice is required to terminate the tenancy. The tenancy automatically ends on the specified date as per the agreement unless the parties mutually agree to extend or renew it. Why not the others? B. 30 days notice is required. This applies to periodic tenancies, not fixed-term tenancies. 6 months notice is required. This is not a standard requirement for terminating a commercial fixed-term tenancy. D. reasonable notice is required. Reasonable notice applies in situations where the tenancy is not for a fixed term or lacks clear terms regarding termination. Question 10. Patty and Henry sign a residential tenancy agreement specified to last for 1 year, commencing on January 1st, 20XX, and ending December 31st, 20XX, but not specifically requiring the tenant to vacate the rental unit at the end of the tenancy. Assuming neither party has given notice to end the tenancy agreement, which of the following statements about Patty and Henry's agreement is true under the British Columbia Residential Tenancy Act? Explanation. Under the British Columbia Residential Tenancy Act, when a fixed-term tenancy agreement ends and neither party has provided notice to terminate, the tenancy automatically converts to a month-to-month tenancy unless the agreement explicitly states otherwise. This provides continuity for both landlords and tenants without requiring a new contract. Why not the others? A. Automatically renew for another 1-year term. This would only happen if explicitly stated in the tenancy agreement. C. Automatically terminate. Tenancies do not terminate automatically unless proper notice has been given or the agreement specifies this. D. Automatically renew for 1 month and then terminate. The law does not impose such a condition. Month-to-month continuation is standard. Question 11. Jenny has rented her apartment on a month-to-month basis for 2 years without a rent increase. She receives a properly delivered rent increase notice on July 31st, raising her rent from $750 per month to $1,075 per month, effective November 1st. She feels this increase is excessive and discusses it with her landlord, but her landlord remains convinced that $1,075 is a fair market value rent, even though the applicable Consumer Price Index, CPI, is 3%. Which of the following statements is true? Correct answer. A. The notice of rent increase is invalid because it is less than 6 months before it becomes effective. Explanation. Under the British Columbia Residential Tenancy Act, a landlord is required to provide at least 3 full months' notice for a rent increase, and the increase cannot take effect less than 6 months after the last increase, or the start of the tenancy if no prior increases. In this case, the rent increase notice was delivered on July 31st for an effective date of November 1st, which gives less than 6 months' notice. Therefore, the notice is invalid. Why not the others? B. The rent increase cannot be valid because it is greater than the CPI. Rent increases are subject to guidelines, but they can still be valid even if they exceed the CP, as long as they comply with the notice period and other rules. C. This rent increase will be valid only if there has been a change of landlords. The validity of rent increases is not contingent on a change of landlords. It's based on the correct notice period and adherence to regulations. D. This rent increase will be valid only if approved for special circumstances. Rent increases generally follow standard rules and do not require special approval unless specific exceptions are involved. Chapter 6. Commercial and Residential Tenancies. Question 12. An assignment of a commercial lease cannot be made by a tenant to a third party in which of the following scenarios? Correct answer. C. Where the tenant is specifically prevented from doing so by a clause in the lease. Explanation. An assignment of a commercial lease is prohibited if the lease contains a specific clause preventing the tenant from assigning the lease to a third party. Even if other conditions are met, such a clause in the lease agreement would override the tenant's ability to assign the lease. Why not the others? A. Where there is a clause in the lease allowing the tenant to do so. If the lease allows the tenant to assign the lease, then the tenant can assign it according to the terms outlined in the lease. B. Where the landlord has not given their consent during the course of dealings prior to execution. If the lease requires landlord consent for assignment, the tenant must obtain that consent. If consent is not granted, the assignment cannot proceed, but it is still a possibility under the lease terms. D. Where the lease permits subletting of the premises. Subletting and assignment are different, but the permission to sublet does not automatically prohibit assignment unless the lease specifically addresses assignment separately.
Question 13. Which of the following is not an example of a situation in which a landlord can end a residential tenancy agreement for cause? Correct answer. C. The premises must be vacated to allow for renovations that cannot be performed while the premises are occupied. Explanation: a landlord can end a residential tenancy for cause in specific situations, but renovations that cannot be performed while the premises are occupied is typically not considered a cause under the Residential Tenancy Act, unless it is directly tied to serious breaches or issues. For renovations, the landlord usually has to follow different rules, such as providing proper notice for ending the tenancy or following procedures for renovictions. Why not the others? A. The number of persons permanently occupying a suite is unreasonable. A landlord can terminate the tenancy if the tenant violates the tenancy agreement by having too many people living in the unit. B. A tenant fails to give the necessary security deposit within 30 days of the date required by the tenancy agreement. Failure to provide the security deposit on time can be grounds for termination. D. The premises must be vacated to comply with an order made by the local authority regarding zoning. A landlord can end a tenancy if required to vacate the premises due to local authority orders, such as zoning laws or safety requirements. Question 14. When determining the rights of a tenant of residential premises, which of the following sources of law must the parties look to? The correct answer is B. The common law. When determining the rights of a tenant in residential premises, the parties must primarily look to the common law and relevant statutes, like the Residential Tenancy Act in British Columbia, which governs residential tenancy agreements and disputes. The other options, such as the Commercial Tenancy Act and Rent Distress Act, are not applicable to residential tenancies. Question 15. There are two ways to surrender a lease under a commercial tenancy. One is by an act of the parties. The other is... The correct answer is A. By operation of law. Explanation: a lease can be surrendered in two ways under a commercial tenancy. 1. By an act of the parties. This involves mutual agreement or action between the landlord and tenant. 2. By operation of law. This happens when certain events or actions, such as the tenant's abandonment of the property or the landlord re-entering the premises, effectively result in the termination of the lease without the need for the parties' agreement. The other options are incorrect because B. Arbitrators resolve disputes, not lease surrenders. C. The public trustee deals with estates, not lease surrenders. D. The Residential Tenancy Board only governs residential leases, not commercial ones. Question 16. Kent rented his Kerrisdale house to Lisa for a fixed term of 3 years, commencing July 1st, 2008 and terminating on June 30th, 2011 for an annual rent of $12,000 payable in equal monthly installments on the first day of each month. On April 12, 2010, Lisa abandoned the premises without giving notice to Kent and without paying the rent for April. The BC Residential Tenancy Act requires Kent to do which of the following? The correct answer is C. Attempt to re-rent the premises and mitigate his damages. Explanation: under the BC Residential Tenancy Act, a landlord must make reasonable efforts to re-rent the premises and reduce the damages caused by the tenant's abandonment, rather than simply suing for the full remaining rent. The other options are incorrect because A. Hiring a bailiff is not necessary. The landlord must follow proper legal procedures for collecting unpaid rent. B. The landlord is not limited to the security deposit. They can pursue further damages. D. The landlord has a duty to mitigate damages, which means they cannot simply demand the full rent for the remaining lease term without attempting to re-rent the property. Question 17. Where a landlord refuses to allow a commercial tenant to take possession of the demised premises, the tenant may. The correct answer is C. Sue the landlord for damages. Explanation: if a landlord refuses to allow a commercial tenant to take possession of the premises, the tenant may sue for damages caused by the landlord's breach of the lease agreement. The other options are incorrect because A. Specific performance is a remedy usually available for contracts involving unique property or situations, but not typically for a lease. B. Breach of the covenant of quiet enjoyment usually refers to a tenant's right to peaceful possession, not the right to take possession in the first place. D. The tenant can take legal action, so this option is incorrect. Question 18. Which of the following statements is true? The correct answer is C. A tenant is usually responsible for reasonable wear and tear to the premises, unless otherwise stated in the lease. Explanation. A. Incorrect. A term in a commercial lease contrary to the Commercial Tenancy Act may be void, but the landlord's enforcement rights are not contingent on reasonable cause. The lease term would be unenforceable. B. Incorrect. The implied covenant of quiet enjoyment ensures a tenant can possess and use the premises without interference from the landlord or others with superior legal claims, but it does not specifically guarantee privacy. D. Incorrect. The doctrine of interest termini means that a tenant's interest in a lease is created only when they enter possession of the premises, not just when the lease is signed. Question 19. In the event that the tenant abandons a commercial premises, the landlord is best advised to notify the tenant that the landlord intends to enter into possession of the premises solely to re-rent on the tenant's account. The correct answer is C, so that all of the landlord's rights against the tenant will be preserved. Explanation. A. Incorrect. The doctrine of frustration applies to contracts being impossible to perform, not to abandonment of commercial premises. B. Incorrect. Not notifying the tenant about the landlord's intention to re-rent does not necessarily create grounds for an action in trespass. D. Incorrect. The covenant of quiet enjoyment protects a tenant from interference, but it does not relate directly to a landlord's actions when a tenant abandons the premises. Question 20. Charlie enters into a fixed-term tenancy agreement with Lucy for the rental of a suite during the school year. The agreement is for 8 months beginning on September 1st. The agreement does not provide that Charlie must vacate the rental unit when the term expires. In April, Charlie finds a summer job and decides to remain in the suite after the original lease expires. He pays Lucy 1 month's rent on May 1st, which she accepts. No new agreement is entered into. 2 days later, Lucy learns that her brother, Linus, has been transferred back to Vancouver and is expected to arrive at the end of the month with his new wife, Sally. Linus has indicated that he wishes to live in the suite now occupied by Charlie. Which of the following statements is true? The correct answer is A. Under the termination provisions of the Residential Tenancy Act, Lucy can give Charlie notice of the end of the tenancy agreement since she intends, in good faith, for her brother to occupy the premises. Explanation. A. Correct. The Residential Tenancy Act allows a landlord to end a tenancy in good faith if the unit is needed for personal use by the landlord or a close family member, such as Lucy's brother Linus. Lucy can give Charlie notice of termination for this reason. B. Incorrect. Since Charlie paid rent for May, a new tenancy agreement has likely been created. Lucy can't evict him immediately just because the original term ended without a new agreement. C. Incorrect. The provisions mentioned are not applicable to a situation where Lucy is renting to a family member. Those terms are typically for situations involving sale of the property or longer-term rentals with specific conditions. D. Incorrect. 1 month's notice is generally required if the landlord plans to end the tenancy for personal use, but there are additional stipulations under the Residential Tenancy Act, such as the landlord intending to move into the property for a specific duration. Question 21. An assignment of a commercial lease may be made by a tenant to a third party. The correct answer is D, unless the tenant is specifically prevented from doing so by a covenant in the lease. Explanation. D, correct. Unless there is a clause in the lease that prohibits assignment, the tenant can assign the lease to a third party. A, incorrect. A provision allowing assignment is not always required, as the tenant may have the right unless restricted. B, incorrect. A license from the landlord is not generally needed for assignment unless specified in the lease. C, incorrect. The landlord's consent cannot always be implied. It must be explicitly addressed in the lease. Question 22. A landlord has rented an apartment to a tenant under a 1-year tenancy agreement. 3 days ago, at the beginning of the 3rd month of the term, the tenant failed to pay rent as due. What action can the landlord take? The correct answer is C. The landlord may now give the tenant 10 days written notice of the end of the tenancy agreement, and the tenant may avoid termination by paying the overdue rent within 5 days of receiving the notice. Explanation. C. Correct. According to the Residential Tenancy Act, if a tenant fails to pay rent, the landlord can give a 10-day notice to end the tenancy, and the tenant can avoid termination by paying the overdue rent within 5 days. A. Incorrect. The landlord cannot immediately enter the premises and seize the tenant's property without following legal procedures, such as getting a court order. B. Incorrect. The landlord is not prohibited from terminating the lease and does not have to go to arbitration at this stage. D. Incorrect. The agreement is not automatically void. The landlord can take action as outlined in option C.
Question 23. Which one of the following accurately describes the law with respect to security deposits on a commercial tenancy? The correct answer is B. There is no limit on the amount of security deposit that may be charged. Explanation. B. Correct. In a commercial tenancy, there is no statutory limit on the amount a landlord can charge for a security deposit. It is subject to negotiation between the landlord and tenant. A. Incorrect. This rule applies to residential tenancies, not commercial ones. C. Incorrect. Security deposits are permitted in commercial tenancies. D. Incorrect. This limit is for residential tenancies, not commercial ones.
Question 24. Which of the following statements about a commercial lease for a fixed term are true? The correct answer is D. All of the above statements are true. Explanation. A. True. A commercial lease for a fixed term automatically terminates at the end of the specified term unless there is an agreement to extend or renew. True. A commercial lease can be for any length of time as agreed upon by the landlord and tenant. True. A fixed-term commercial lease must specify the commencement date and duration of the lease term. Question 25. Larry owns a large gift shop. For the past 8 years, Larry has allowed Marie, a jeweler, to use an area in the back room of the gift shop as a workshop. Larry and Marie have an oral agreement that Marie will only use the workshop area during weekday mornings when the gift shop is not busy, so as not to disturb customers with the noise of her work. Marie pays $350 each month to Larry for this right. Larry has sold the shop to Theo for use as a restaurant, but he is uncertain what to do about his agreement with Marie. You correctly advise Larry that the correct answer is C. The agreement between Larry and Marie is not enforceable against Theo because it is only a license. Explanation. Larry and Marie have an oral agreement that allows Marie to use the space, which is a license, not a formal lease. A license gives permission to use the property but does not create a tenancy or leasehold interest in the property. Since it is a license, it is not enforceable against Theo, the new owner, because a license is personal to the original parties and can be revoked unless there is an agreement to the contrary.
Question 26. Which of the following best describes the main difference between a lease and a license? The correct answer is A. Licenses are governed by the ordinary law of contract and confer no interest in land, whereas leases convey an interest in land. Explanation. The main difference between a lease and a license is that a lease gives the tenant an interest in land, meaning it confers exclusive possession of the property for a specified period, while a license is a permission to use the property but does not grant any ownership rights or an interest in the land. Question 27. When Joan was viewing the apartment in a converted house that she was contemplating renting from Zach, she noticed that the steps and the handrail in the back staircase appeared to be in a state of disrepair. When Joan moved in after signing the lease, she discovered that she could not use the back stairs because the bottom 3 stairs were rotten and the handrail was not bolted down. Which of the following statements is true? The correct answer is D. Zach is obliged by law to maintain the premises in a state of repair that complies with safety standards, irrespective of the condition of the premises at the time the lease was entered. Explanation. Under the Residential Tenancy Act in British Columbia, landlords are required to ensure that rental properties meet health, safety, and repair standards. Even if the lease does not specify repairs, the landlord is legally obligated to maintain the premises in a safe and habitable condition. This includes ensuring that stairways and handrails meet safety standards, regardless of the condition when the lease was signed. Question 28. Erica owns a 12-unit residential apartment building and has notified Chris that she must terminate his tenancy because she is planning for repairs that can only be conducted if his unit is unoccupied. Chris does not want the repairs. However, he has notified Erica that if they must be conducted, he would like to return after the repairs are complete. Which of the following statements correctly describe Erica's obligations to Chris? The correct answer is C. Erica must offer Chris the right of first refusal to enter into a new tenancy agreement after the repairs are complete at the previous rate of rent. Explanation. Under the Residential Tenancy Act in British Columbia, if a landlord ends a tenancy for repairs or renovations that require the unit to be vacant, they must offer the tenant the right of first refusal to return to the unit once the repairs are complete, and the tenant must be offered the unit at the previous rental rate. Question 29. Diana leased an apartment from Horst for 12 months commencing January 1st and has agreed to vacate the apartment when the term expires. On April 1st, Horst conveyed the building to Bing. On April 15th, Bing gave Diana a notice to end the tenancy agreement effective May 15th. The reason for the termination was that Bing wanted the apartment for his daughter, who had recently been married. Under the Residential Tenancy Act, what is the earliest date by which Bing can require Diana to leave? The correct answer is A. May 31st. Explanation. Under the Residential Tenancy Act in British Columbia, a new owner, Bing, must provide at least 2 months' notice to end the tenancy for personal use, like wanting the apartment for family members. Since Bing gave notice on April 15th, the earliest date Diana can be required to vacate would be May 31st, which is 2 months from the notice date. Question 30. When, with respect to commercial tenancies, there is said to be an implied covenant of quiet enjoyment, it means. The correct answer is C. That the landlord provides assurance to the tenant against the consequence of a defective title involving the landlord or those lawfully claiming under them. Explanation. The implied covenant of quiet enjoyment in commercial tenancies means that the tenant has the right to occupy and use the premises without interference from the landlord or anyone else claiming through the landlord. This protects the tenant against disruptions due to defects in the landlord's title to the property. Question 31. Which of the following statements is false with respect to residential tenancies under the provisions of the Residential Tenancy Act? The false statement is D. A landlord may only increase rent once per year and must provide written notice at least 3 months before it becomes effective. Explanation. Rent increases must be in writing, but they must be provided at least 3 months in advance, not just orally. The key part that makes D false is the notice requirement, which is not oral. Here's a quick breakdown of the other options. A. With the consent of the landlord, a residential tenant can assign or sublet all or part of the leased premises at any time during the term of the tenancy. True. Tenants can assign or sublet with the landlord's consent as long as the lease doesn't explicitly prohibit it. B. A landlord is entitled to give not less than 1 month written notice of the end of the tenancy agreement to a tenant who, after 2 months of entering into the tenancy agreement, has failed to give the security deposit required under the agreement. True. If a tenant doesn't pay the required security deposit, the landlord can end the tenancy with 1 month's notice. C. In cases of emergency, a landlord has a right of entry to leased premises. True. A landlord can enter the premises without notice in an emergency, such as to prevent damage to the property. Question 32. With respect to commercial tenancies, the covenant of quiet enjoyment is PEW, best described as which of the following? The correct answer is D. An assurance to the tenant against the consequences of a defective title involving the landlord or those lawfully claiming under the landlord. This option describes the covenant of quiet enjoyment as it relates to the tenant's right to peaceably enjoy the premises without disturbance from the landlord or anyone claiming under the landlord's title, which includes protection from issues related to the landlord's legal ownership of the property. Here's a breakdown of why each option is incorrect. A. The covenant of quiet enjoyment doesn't focus solely on noise, but on ensuring the tenant has undisturbed possession of the property. It's broader, covering things like the landlord or third parties not interfering with the tenant's use of the space. B. The covenant of quiet enjoyment doesn't require the tenant to obey noise bylaws. That's the tenant's responsibility. It's about the landlord ensuring they, or others, don't interfere with the tenant's possession. C. This refers to the landlord's duty to maintain the premises in a habitable condition, which falls under a different set of obligations, not quiet enjoyment. D. The correct interpretation is that quiet enjoyment means the tenant has assurance they won't face problems due to the landlord's defective title, i.e., issues with the landlord's legal right to lease the premises. This protects tenants against claims of ownership disputes. Question 33. A tenancy agreement as statutorily defined. Explanation. A. A tenancy agreement does not automatically grant the right to distrain, seize, a tenant's goods. Distraining is a separate legal action for rent arrears and is subject to specific conditions. B. Tenants are generally not required to carry out all repairs and maintenance. This depends on the lease agreement, but the landlord usually bears the responsibility for major repairs and maintenance. C. A tenancy agreement does not need to be registered in the Land Title Office to secure a tenant's rights. Residential tenancies are typically governed by the Residential Tenancy Act, which doesn't require registration. D. If a residential tenant abandons the rental unit, the tenancy is typically terminated. This can depend on the circumstances, but abandonment can lead to termination under the Residential Tenancy Act. Question 34. Which of the following is not an essential requirement of a lease? The correct answer is D. The addresses and occupations of the parties. Explanation. A. The name of the parties is an essential requirement for a lease to identify who is entering into the agreement. B. A description of the premises being leased is necessary to specify the property involved in the lease. C. The rent is a crucial element as it outlines the tenant's obligation to pay for the lease. D. While addresses and occupations of the parties can be included for clarity, they are not essential requirements for a lease to be valid. The key components are the parties' names, the description of the premises, and the rent. Question 35. Under the Residential Tenancy Act, the landlord is entitled to collect a security deposit equal to, the correct answer is B, 1 month's rent. Explanation. Under the Residential Tenancy Act, a landlord is entitled to collect a security deposit equal to 1 month's rent. This deposit is typically held as security for any damages or unpaid rent during the tenancy. Question 36. The duty to repair commercial premises. The correct answer is D, is generally a landlord's obligation unless the lease specifies otherwise. Explanation. In a commercial lease, the duty to repair the premises is generally the landlord's responsibility, unless the lease specifically states otherwise. However, this can vary depending on the terms of the lease agreement. A. Is incorrect because the duty to repair is enforceable even if the lease is not registered in the Land Title Office. B. Is correct because having the duty to repair in writing in the lease helps avoid disputes between the lessee and lessor. C. Is incorrect because the duty to repair typically excludes responsibility for fair wear and tear, which is not considered a repair obligation. Question 37. The most effective remedy available to a landlord when a tenant does not pay the rent in a commercial tenancy is C. Distress is the correct answer because distress allows the landlord to seize the tenant's property to recover rent arrears. This remedy is commonly used in commercial tenancies when rent is unpaid. A. Injunction. This is not typically used for unpaid rent. It's more for preventing specific actions. B. Garnishing order. A garnishing order could be used to seize money directly from the tenant's bank or wages, but it's usually a later step after distress or legal action. Distress. The most effective remedy for unpaid rent in commercial tenancies, allowing the landlord to seize the tenant's property to recover rent. D. Demand letter. While useful for notifying the tenant of overdue rent, it doesn't directly resolve the issue or recover unpaid rent. Question 38. In the situation where a residential tenant under a fixed-term tenancy abandons the premises prior to the end of the term, the obligation imposed on the landlord to try to re-rent the premises as quickly as possible is referred to as, the correct answer is A, the duty to mitigate damages. This means the landlord must make reasonable efforts to re-rent the premises after a tenant abandons the property in order to reduce the financial loss from the tenant's departure. B, the covenant of quiet enjoyment ensures that tenants can peacefully enjoy the premises without disturbance, but it doesn't relate to the landlord's obligation to re-rent. C, derogation from the grant refers to the landlord interfering with the tenant's use of the property, which is unrelated to the landlord's duty to find a new tenant. D, the doctrine of interest termini concerns the legal principle that a lease does not take effect until the tenant takes possession, which does not apply to a landlord's obligation to mitigate damages when a tenant abandons the premises. Question 39. Lawson has rented his warehouse to Tyler, who runs a moving and storage business. Which one of the following is not a remedy available to Lawson if Tyler fails to pay his rent? The correct answer is D. Lawson can apply under the provisions of the Residential Tenancy Act for an arbitrator to be appointed. The Residential Tenancy Act applies to residential tenancies, not commercial tenancies, so Lawson cannot apply under this act for arbitration. A. Lawson can re-enter the premises and forfeit the rent payable for the balance of the rental period is a possible remedy in commercial leases if this right is specified in the agreement. B. Lawson may seize the personal property of Tyler and sell it in order to pay the arrears of rent, refers to distress, a remedy available to landlords under commercial tenancies for rent arrears. C. Lawson can sue Tyler for the rent, as would any creditor, is a valid remedy for rent arrears in a commercial tenancy, allowing the landlord to pursue the tenant for payment through legal action. Question 40. Which one of the following is not a required provision in a lease? The correct answer is D. The previous address of the lessee is not a required provision in a lease. Explanation. While the lease should contain essential information like the amount of rent and method of payment, the commencement and term of the lease, and the signatures of the parties, the lessee's previous address is not a required provision. It may be included, but it is not a mandatory element for the lease to be valid. A. The amount of rent and method of payment is essential for defining the financial terms of the lease. B. The commencement and term of the lease are necessary to establish the lease period. C. The signatures of the parties are needed to demonstrate mutual agreement and enforceability of the lease. Question 41. Which of the following is not required in a notice of the end of the tenancy agreement by a tenant under the Residential Tenancy Act? The correct answer is C. The occupations of the parties is not required in a notice of the end of tenancy agreement by a tenant under Residential Tenancy Act. The occupations of the parties are irrelevant and not part of the statutory requirements. Explanation. The occupations of the landlord or tenant are not required in a notice of termination under the Residential Tenancy Act. The notice must include A. A written notice signed by the tenant to formalize the intent. B. The address of the premises to clearly identify the rental unit in question. D. The date of termination to specify when the tenancy will end.
Question 42. A commercial periodic tenancy is, the correct answer is C, a tenancy that automatically renews itself on the last day of the term for a further term of the same length until it is terminated by either party upon proper notice. Explanation. A commercial periodic tenancy is defined by its self-renewing nature. At the end of each term, e.g., weekly, monthly, or yearly, it automatically continues unless one of the parties provides appropriate notice of termination. Other options. A. A term lease. Incorrect, as a term lease has a fixed duration and does not automatically renew. B. A lease for a certain period of time. Incorrect, as this describes a fixed-term lease, not a periodic tenancy. D. A tenancy created in a commercial context after the entering of the lease and prior to possession by the tenant. Incorrect, as this does not describe a periodic tenancy, but rather a tenancy at will or another arrangement. Question 43. When attempting to determine whether a particular relationship is that of landlord and tenant or licensor and licensee, it is best to The correct answer is B. Look at the substance of the agreement between the parties. Explanation. The nature of the relationship is determined by the actual substance of the agreement and the rights granted, such as exclusive possession rather than the formal wording. Even if a document labels the relationship as a license, it could be deemed a lease if exclusive possession of the property is granted. Other options. A. Look at the formal wording of the document. Incorrect, as the terminology used in the document is not conclusive. Substance takes precedence over form. C. Consult the Residential Tenancy Act. Incorrect, because this applies specifically to residential tenancies, not all landlord-tenant relationships. D. Consult the Commercial Tenancies Act. Incorrect, as this legislation governs commercial tenancies, but is not the primary tool for distinguishing between a lease and a license. Question 44. Which of the following statements about periodic tenancies is true? The correct answer is D. Where a fixed-term residential tenancy expires, it will automatically convert to a month-to-month periodic tenancy, unless the parties have agreed in writing that it will not do so at the time they entered into a fixed-term tenancy agreement. Explanation. Under the Residential Tenancy Act, a fixed-term residential tenancy typically transitions to a month-to-month periodic tenancy upon its expiration unless there is a prior written agreement specifying otherwise. This ensures continuity of tenancy without requiring a new agreement. Other options. A. Rent will be increased by 10%. Incorrect. The terms of a periodic tenancy following a fixed-term lease generally remain the same, including rent, unless the lease or governing laws provide for an adjustment. B. Periodic tenancy will be for a term of 5 years. Incorrect. Periodic tenancies do not inherit the fixed term's duration. They renew automatically based on the payment schedule, such as monthly or yearly. C. Cannot be terminated for 1 year. Incorrect. Either party can terminate a periodic tenancy with proper notice as specified by law or the lease terms. Chapter 6, Commercial and Residential Tenancies, Question 45. Martha, who has been George's landlord for the past 3 months, has seized George's furniture from his rented premises and threatens to sell the furniture in order to pay George's arrears of rent. Which one of the following statements is false? D is false statement. Martha has taken an action that can be described as a classic example of a private nuisance. Explanation. Private nuisance involves interference with the use or enjoyment of land, not actions related to rent collection or property seizure. Martha's actions are unrelated to nuisance laws. Other options. A. Illegal remedy if the premises is a personal residence. True. Under the Residential Tenancy Act, distress is prohibited for residential tenancies. B. Remedy called distress or distraint. True. Distress refers to the landlord's right to seize and sell a tenant's property for unpaid rent, which is still valid in some commercial tenancies, but not residential. Most effective remedy if the premises is a warehouse. True. For commercial tenancies, distress can be an effective remedy if allowed under the lease and applicable laws.